Welcome to another episode of the SharkCast on litigation risks management, where we explore why businesses are so frequently sued and how to mitigate and navigate the dangers lurking in these risky waters. Join us now as we welcome our host, Kent Schmidt, litigation partner at the law firm of Dorsey & Whitney.
Welcome to another episode of SharkCast. I really like to begin SharkCast by talking about any unusual aspects of an episode, including milestones in the short history of this podcast. And today we have another milestone. We covered a number this year, including our first international guest several weeks ago. But this is the first time we've had what I'm calling an encore episode.
Woo!
Backed by popular demand. You know, you got to give the people what they want. I have my partners, Nisha Verma and Heather Dillion, joining me here in Southern California to talk about one of our favorite subjects, a subject that certainly is reflective of how often companies are sued. And that is, of course, labor and employment litigation. If you missed our earlier episode, we focused a little more specifically on the post-COVID world and some of the challenges that brings to employers in employment litigation claims and adapting their policies and practices to the brave new world in which we live. But the world moves on. And one of the interesting things about employment law is how nimble it is to whatever the issue or controversy or trend is of the day. And certainly COVID was reflective of that. You saw all sorts of new COVID legislation and new theories that came about by employment lawyers as a result of COVID. But all sorts of new trends and new phenomenon are occurring in our society today. So I thought we would talk about some of those and what changes those shifts in our society and new emphasis bring to employment litigation risk. So first of all, thanks both of you for agreeing to come back to SharkCast, and congratulations on being the first encore guest.
We are honored. Thank you for having us
Great
back.
to be here.
All right. Well, let's jump right in. I would first like to address something that used to be somewhat unique to a handful of jurisdictions, including, I think, first Colorado and then California, but now is spread to, I believe, half or close to half, maybe over half of the U.S. states. And that is the legalization in some form or another of cannabis. Many jurisdictions, such as California, begin with medical use of cannabis being permitted and then move thereafter into recreational use. Other states go straight to recreational use. But in California, we're dealing more and more with the various implications of legalized cannabis and somewhat increasing popularity of cannabis use. And that bumps up against certain employment practices and employee policies. So using California somewhat as a catalyst, but also to the extent you want to comment on other jurisdictions, how is the use of legalized cannabis in a particular state impacting employers' rights and obligations?
It's impacting it quite a bit. I mean, there has been a big shift change into the overall appetite, if you will, for cannabis or ability to be okay with it. It used to be so taboo. And when I was in law school, which was a little over 10 years ago, I remember California had a bill and it was shot down to legalize cannabis. And now here we are advising employers on what they need to do because it's legal here in California. Cannabis is interesting because it's very different than alcohol, right? Alcohol, you could have a breathalyzer and it's, hey, you are over the limit currently. You are currently under the influence.
At this minute.
At this minute, under the influence of this, there's some leeway there, but of this substance. With cannabis, you have this THC that stays active in your system for, it could be over a month. So someone could have used cannabis and then 3 weeks down the line, get tested for it and show up positive, even though they were not under the influence of it at that time. So it's the psychoactive aspect of THC that California now says employers can care about. So what that means is California now, as of January 1st, employers cannot make an employment decision based on a non-psychoactive identification of cannabis. So meaning you can only use tests that show that the psychoactive portion of cannabis is present, meaning that they are currently under the influence of cannabis.
So I want to make sure I understand this. If I'm operating a small business in California and for whatever reason, social reasons or drug history in my family, I voted against, legalization of cannabis when it was a proposition in California. I don't like cannabis use. I think it's one of the bad things in our society. I cannot bring that personal view and policy to my workforce and say, we're still a drug-free work zone, no cannabis users.
Well, that was kind of a loaded question there. There's two parts, right? The first part, I thought you were going to say this. I don't ever want anyone to ever be able to use cannabis.
On the job?
No, that stays. On the job is fine. Employers can still have a drug-free and alcohol-free and violence-free workplace. It's that you cannot, then this is where I kept saying the psychoactive sounded a little bit like a biologist there, but the psychoactive versus non-psychoactive aspects of THC. So you cannot make an employment decision for an employee based on the presence of non-psychoactive THC, which means at some point in time, they have used marijuana. But was it being used at the workplace?
Or at the time they showed up for their drug test, which could be like 5 days before they started work, right? But if your applicant is responsible enough to not be impaired or have used recently enough for their drug test at which they're not working at, but they know what's happening, then that is essentially what we're looking at. Can your applicant plan ahead enough to make sure that they have not been impaired anytime right before their drug test, as opposed to can your applicant plan ahead enough to make sure they're not taking an edible 5 weeks before their drug test, which is the old system. Either way, you'll never know whether the person doesn't use marijuana. Like, you'll just know what was captured at the moment in time test.
So everything you're talking about really is the liability is triggered by the drug testing and decisions on employment made based on drug testing.
Correct.
Is that correct?
Correct. And what California is saying now is that if you are going to drug test for marijuana, you need to make sure you are using a test that only identifies, or that at least marks out, that this is the psychoactive THC. And they exist. The tests exist. They're not as commonplace, but I imagine with it becoming legal, we're going to see it more everywhere because we want police officers to be able to find out, is this person impaired while driving? Let me figure this out right now. So that's really the change in it, is that you cannot make an employment decision based on the non-psychoactive aspect of marijuana. Think about it with alcohol. If I had a drink 2 nights ago at dinner, and I'm interviewing with you right now, are you going to deny me an employment because I had a drink 2 nights ago? No. And that's kind of how it is if I had an edible 2 nights ago, is that something that you're going to deny my decision based on now?
Or 5 weeks ago right. Before you applied for the job. Right. To be fair, 5 weeks ago before you applied for the job or knew the job existed or had any interest in it, right? Like, that is what the old system was catching.
So let me go back to my question. Not the first time I've been accused of asking a loaded question, but let me revert to that and say, let's suppose in my scenario, I'm not going to do any drug testing, but I just make it clear we're a drug-free zone. It's still illegal on a federal level. It's still listed narcotic. It's the listed substance. And so I say, I don't care what California is doing. I want to have a drug-free zone. And if I hear about someone using marijuana, even recreationally, even on the weekend, I'm not interested in you continue to work at my small business.
Yeah, the law directly addresses that, because while the more often talked about provision of the law addressing drug testing is what we were talking about a moment ago, and that's what's in the media more, that's what's in discussion more, it is still prefatory, it is still a prong that an employer cannot make a decision based on the person's use of cannabis off-duty and off-site.
Let me pivot the question then a little bit. So I'm a prudent employer. I understand I can't expressly make a decision, but I'm very concerned about drug use and my employees being impaired on the job. I'm not going to do any testing, but I know when someone's high. I've been around the block a time or two. Can I make an employment decision based on my perception?
I would do the test. I don't mean to cut off your question, but why wouldn't you? I would do the test. Before 2188, right? AB 2188. Pre-employment testing has been legal in California, and there's always been the right to test for reasonable suspicion or post-accident. So if you're saying that there's objective criteria, typically we want by two separate managers have seen that the person's impaired, then what I would do in that situation is require a drug test, which was perfectly legal before and after 2188, and only test using the 2188 standards,
The active
that
kit.
Heather was describing. And if your suspicions are correct, it'll come back positive and fire the guy. Done.
Okay.
There's also another test that's allowed. It's called the impairment test. But you really what you have to do is take a baseline measure of all your employees. So we see how you are today.
Maybe they acted like they were high before.
Right.
Before.
Just come in and blubbering idiot. If you save that job, use that as your baseline. No, but you can. So there is another way to do it. I think it's dangerous. The impairment test, I think, really allows for a lot of personal biases to come in. So I would not advise towards that. But if you see someone clearly impaired by whatever it might be, it's that you can still potentially have grounds for termination.
So let me bottom line this. If you're going to start focusing on or making employment decisions, or you face an issue of impairment from cannabis or any other substance for that matter, you may have some rights as an employer, but tread carefully, get some legal advice. Just don't go making decisions that instinctively feel like, yeah, this is the right decision to make, right?
I would say that was so much. It was so many things. I feel like a lot of our instincts as business owners tend to be very personal, and use your counsel to go through.
And with cannabis, it's sort of understandable since it's still illegal on a federal level. So
it is, but for how long?
Yeah. Well, we've been hearing that for a few years. So, well, let's pivot to another issue relating to the workplace and relating to what is happening in our society, and it's the sad reality of workplace violence. Every several weeks or a month or so, you turn on cable news and you see some other act of violence that occurs in our schools or in our workplace. And obviously, we're going to focus on the workplace. What are legislatures doing to address workplace violence, particularly in California?
California has a new OSHA standard, which is first in the nation, specifically addressing workplace violence. A little bit of background, right? Federal OSHA governs workplace safety. There are a number of states that have essentially permission from federal OSHA to run their own state program. California's state program has been tasked with addressing workplace violence and putting in specific rules around that, and not just general safety, for years. And those rules have been unfinished. And we've had a very active legislature this year. And one of the examples of that is a legislator just stepped in and said, I don't know how long you guys are going to take. Sick of waiting. I want my own rule. I like this rule. And that's where we are, right? So was this drafted by people who have been working on it for 6 years and have every insight into workplace safety? No. This happened through the political process.
Somewhat reflexively and reactively, which Sacramento is just famous for.
And in this case, I completely understand the legislator that sponsored this bill had a mass shooting in his district at a workplace. And I'm thinking of one. There were probably more than one. And so that's how we got here. And this law did not get passed without controversy, because you may have heard of this law previously as the one that legalizes shoplifting in California. So a couple of reasons that's not possible. It's not a criminal law. It's a workplace standard law. However, there was a provision early on that said that prohibited employers from requiring individuals to confront shoplifters. And that drew heavy opposition from business leaders, small business leaders, eventually was pulled. And after that, we ended up with this workplace safety standard.
There's a lot of misconception about that the California passed you cannot do anything about your shoplifters, but that's not true. That's not the version that finally went through.
Okay, so where's the law today? And it's going to be effective and in place January 1st?
Actually, July.
July of 2024.
So
what solution has Sacramento come up with that is going to address workplace violence, and what does it mean for employers going forward after July 1st?
I could say objection assumes facts, not evidence to the term solution, right?
Another loaded question.
I think there's questions around how solution oriented the ultimate policy is here. And so I'll tell you exactly what the three prongs are, right? I mean, the three new requirements are a workplace prevention plan that is, technically a piece of paper, but I would hope employers make it a little bit more live and interactive than that. A log in which someone has to record all workplace violence incidents, and then specific training that addresses both the plan and the log. So my concern around results here is that this creates a lot of homework, a lot of ticking off of boxes to get
record keeping
to get the plan exactly perfectly right, that there's the possibility that whoever's tasked with that will feel so proud of themselves when they're done, they'll just put it in a binder and there it goes away. And will that make anybody's life safer? Will that save a life? Right. And so I think that employers have to do a lot of work here, but not lose sight of the goal, not lose sight of the fact that this is actually important to their employees.
So when you say a plan, what are the basic components of what you're referring to as the workplace violence plan?
Yeah. So this is one of those statutes that goes all the way down to like Z in terms of but the highlights are the place. So there's already a requirement to have an illness and injury prevention plan that employers are subject to. As separate from that, or and kind of appendix to that plan, they need to have a specific workplace violence prevention plan that hits on a lot of topics, including how to alert employees regarding emergencies, how to identify and resolve existing workplace hazards. But what I think is interesting about this, because look, there's a lot of requirements, somebody who's very smart can figure all that out, right? But I think what's interesting about it, and this is going to come up again, because it's a theme in this legislative session and nationally, is almost bargaining level relationship with employees on what they want around this, because this law specifically requires that the plan include active involvement by the workforce, supervisory and non-supervisory, in developing the procedures.
So you can't just have someone sitting in an ivory tower determining what is going to happen for their company.
You got to have all the stakeholders involved, including the rank and file employees that are having some sort of contribution to the plan.
Correct. And we do expect Cal OSHA to release some sort of blueprint as to what this should look like. How detailed will it be? We don't know yet, but we are expecting them to roll out some sort of example soon.
Yes. So I can think of all sorts of litigation, perhaps not directly related to this. This is going to start bumping up against these type of issues. Privacy, once you start creating a record of workplace violence, what are the rights of employees to know what is in that record?
Mm-hmm. Yeah.
And what are the obligations of the employer once they created a record? Then you even have defamation that comes up. If I lost my cool at the water cooler the other day and someone jotted it down in the workplace violence log, then I have some sort of defamation claim. Is there any immunity for recording these by the employer?
So to answer your access question first, the access is broad. So the workplace violence log, which I'll describe in a second, ultimately can be accessed by employees, and employees have to be trained on that. There's requirements that the information has to be prepared in a way that doesn't identify anyone. But look, if you only have one water cooler and you only have one guy that loses it at the water cooler, then that information of what happened is without that person's name or other identifying characteristic, it's going to be there. And that's a reality.
Well, I am as against workplace violence as the next person, but I can just see a lot of litigation that comes from this record keeping requirement and
logistical nightmare and litigation.
Exactly.
Yeah, I think that, from a litigation perspective, I think the fact is that it requires a significant investigation or requires conclusions as to essentially what factors led to the violent incident. And I will just know that the type of violence can include threats, and it can include a threat of psychological trauma, right? Not necessarily harm. So I would note that I have definitely worked with plenty of employers that have multiple members of their family in the workplace, and you can see how something that happened at home can bubble over into work. And yeah, that usually would involve at least a threat of psychological trauma. So there's a lot of thinking through about what needs to be put in the log. But then when this designated person, and I would recommend it be one person, is preparing the log, while they need to be thinking most importantly about what this says about the culture of the workplace, what this says about safety overall, unfortunately, in the back of their head, they have to also be thinking about litigation, because obviously this is discoverable, and it's kind of requiring an admission as to aspects that could have prevented this incident that you are now describing in detail.
That's a scary proposition, that you're going to record something that could later be used against you in a workplace violence claim or other type of claim, ranging from defamation to just wrongful discharge. But maybe there's no solution to that.
We'll see. Give it some time. I mean, hopefully we'll figure it out, and if there needs to be kinks or changes, that they work together.
I think you're going to ask about this in a little bit, just in terms of speech in the workplace and what can be discussed in the workplace and everything. So this is just another example of almost everything being out in the open.
Well, speaking of all these interactions among employees and heated conversations that maybe arguably in some instances, clearly in others, rise to the level of workplace violence, obviously our society is becoming more and more polarized. Issues in the news and world news, including what's going on in the Middle East with Israel and Gaza, are causing people to bring their viewpoints into the workplace, and arguments erupt. We're heading into an election year next year, so we have those issues also. How is an HR director or someone in charge of employment able to reduce the number of incidents that are distracting from the work in a normal employment place? I'm not talking about a newsroom or something of that nature, just a regular employment place, when you have people that have diametrically opposed opinions politically or socially or based on world events, that are arguing with each other and things are escalating.
So I've spoken on this topic a few times since 2020, and I have some updates in terms of what's gone on in 2023. But my answer is there's a certain extent where you just need to let people feel their feelings, and you need to grow a thicker skin around those feelings and find a way to manage through and find productivity wherever you can. I think the issue of workplace speech and employees bringing their opinions relating to the outside world to work is here to stay. I also think that there is no outside world when it comes to work for a lot of employees, in the sense that they have such a strong they have such a strong connection, or at least an expectation, that their organization participate in every aspect of the outside world, as opposed to just their kind of area of commerce, that most employees are not going to be willing to separate, say, their expectations of their employer from what they expect to happen at work.
So let me, again, ask some loaded questions, pushing back a little bit.
Yeah.
I'm going to put myself in the small business owner position again. And I'm going to say a very, I think, intuitive policy that I might implement. Let's suppose I'm running a factory and I've had a lot of arguments in the break room, not on the line because the machine's running too loud, but in the break room where they're preparing for the next shift about politics or about world events. And I just want to have a policy that says, come in, you can talk about the weather, you can talk about what you did the last weekend, but we're not going to have any more political debates or arguments in the break room or in the locker room where you're getting ready to start your shift. Is that prohibited?
I think so. I think that you can prohibit conduct in the break room.
Right. It requires civility, and that you're not screaming at each other. You're not, no fists are being thrown. But regarding something like political speech, I mean, under the NLRB, I think you can't do much. And the NLRB for this case covers all employers.
Correct. Meaning the conduct of yelling in the break room, or the conduct of fighting, whatever they're fighting about, even if it's about, Beanie Babies, can be prohibited. I think the content is much harder to do. So there's very specific developments under the NLRB, through the NLRB, National Labor Relations Board, which some employers think apply only to unionized employers, but the rights that I'm talking about grant employees the right to engage in protected concerted activity, meaning the right to discuss among themselves what would be in their best benefit, which, maybe is a union, but if it's not, it's still protected by the NLRA. That has time and time been extended to conversations about workplace safety, about understaffing, but also just about how is my employer responding to Black Lives Matter. That for sure has gone before the NLRB, right? And so an update from this year's NLRB is that the kind of workplace rules you can put into effect have changed. There's been a lot of flip-flop in terms of like a handbook rule. What is an impermissible handbook rule? And the standard has been tightened this year in the sense that any rule banning overly broad confidentiality policies, discussions in the workplace, taking photos in the workplace, social media about the workplace, the NLRB can challenge those, or an individual employee through the agency can challenge those if they can just show that the rule has a reasonable tendency to chill employees from exercising their rights. And if the NLRB meets that standard, then the employer has to show a very substantial business interest. And very often, you hurt our feelings or you hurt someone's feelings. And I do deal with the NLRB all the time, more than I like to, but almost every day. But, you hurt my feelings or someone's feelings were hurt is not a substantial business interest.
What about the substantial business interest of, I just don't want politics discussed in the workplace because it's distracting and it undermines the unity in our workforce. So we want to make this a non-political environment.
So there's already, though, long before any of the recent social events we've been talking about, there has always been a prohibition on taking any measure against anyone relating to their off-duty political conduct, right?
But even if it's even-handed, like I don't want to hear from the right or the left. In other words, I'm not just saying I don't want to hear from one political viewpoint. I just don't want any politics in the workplace. That's not permitted?
I don't think so. If the person's doing their job and they're talking about politics in the break room, one, their discussion of politics very well could be seen as protected concerted activity under Section 7. And second, because that they're talking about politics, now something about their political views. So they very easily can say that you're taking action on off-duty political conduct because you were talking about it, right?
So here we have another example where the intuitive, common sense approach of an employer could get them into some hot water. Because it seems to me, and I think you'd agree, that a common sense approach would be, let's just have a non-political workplace, right?
I don't know. What is politics, right? Politics is not just something that happens in Washington or in Sacramento. It's a system. It's how our government is run, which results in rules and regulations that dictate how we act in every business everywhere and in not businesses at home too, right? So
it's not just elections, it's social issues in the world that we all live in. And so to stifle that speech, you're running into some trouble.
But I also don't think it'll work.
It's not possible to stop.
That's what I'm saying. I think I spend a lot of time talking to employers about this, particularly relating to the situation in Gaza that you mentioned. And I think that we live in an age of protest. We have been for a while. That when the Hollywood strike was happening, I could just tell my employers, my clients as shorthand, half of LA is on strike. And, I made the point very succinctly. Kind of sad that's over. So it's not so easy to make that point anymore. But we absolutely live in an age of protest, and typically effort that's seen by any employee as suppressing speech, more than likely it's just going to result in more speech, even if the employer doesn't hear it all. And it may also create distrust and resentment among people that aren't even engaging in the speech that you were worried about.
So the medicine could be worse than the disease.
That's kind of that's something that I spend a lot of time thinking about. Yeah.
I think I lean in a bit different of a direction than Nisha. Just that I hear you, and I believe there is some happy medium. And there was actually a case recently in the news for a grocery chain where their employees were prohibited from wearing BLM masks. Mm-hmm. And the court did throw that case out and said that the grocery chain was able to say, listen, this is we said you have to wear a mask during, when COVID was at its height, or you still can wear a mask, but it has to be plain. We want it absolutely plain. So they said they wanted to foster an inclusive, welcoming environment for their customers. And the court agreed with them. So there are still potentials to say, you can't.
We're going to be neutral on these issues.
Right. But speaking amongst one another, prohibiting them saying, I support BLM, that probably runs afoul.
I am of the same mind. I tell my clients all the time, most jobs other than being Miss America don't require you to be Miss America all the time. And I don't think there's very many jobs that require you to be Miss America or Miss Congeniality in the break room. And if you're upset about something that you saw on the news today and you want to talk about it with someone, I think the break room very often will be a place where you feel your feelings. And I think employers might have to just manage through that.
Well, that's very, very interesting takes on both of those issues. Let's turn now to an economic issue that's driving our employment matters that are emerging. We're talking about the inflation that we've been living with for many months now, the cost of living increasing on a number of different levels, and wage disparity. What is California doing to lead the nation and be the cutting edge state and maintain that reputation as it always has on wage issues?
You get more money. You get more money. Not
That's
everybody
right.
gets more money, though. California has been a leader in the minimum wage, I would say, with some exceptions potentially, but they have again increased their minimum wage. What's really interesting in California specifically, we're seeing new regulations pass through on an industry specific basis. So we have hotels, we have healthcare workers,
and fast
food. So 3 very different industries.
And very significant employers on a volume.
Correct. Yeah. And I think the healthcare one, correct me if I'm wrong, started basically after COVID. And most of us were, yes, please give them more money. My gosh, What have they been going through? And then was hotel. And most recently in this past legislative session was fast food.
So specifically California wide, I believe the fast food and the healthcare increases are the first industry specific, which is this session. I believe prior to that, it was on a municipal level, like certain healthcare workers in city of X,
Palo Alto,
right,
or hotel workers in Beverly Hills. And so I would note that I think it's important to note that both of these measures, the fast food worker and the healthcare worker statewide measure, I would say one of the reasons they passed is because they at least created a consistent standard statewide, as opposed to what is the next city council going to do and where, and time-wise, right? Like we're on a very much, with the healthcare minimum wage, it's going up June on specific years. Whereas if you're talking about a city council, they could implement something mid-year, any year, right? And I think it's very important to understand one of the reasons the healthcare minimum wage, which will go to $25, but it differs as to when, depending on the employer, is that one of the reasons it passed, and that there were some entities that supported it, right? It ultimately passed because some employers or some representatives of employers withdrew their opposition, because a very key provision is that there's a moratorium on local municipal minimum wage hikes for these workers.
I see. So that's the trade-off. They don't have to worry about Palo Alto or San Francisco or Los Angeles increasing it even more.
That's right.
So it's kind of like a state preemption.
It's express preemption, right? Going back to law school, if you want to, because when you're reading the statute, which is a bear to read, but like you get down to this moratorium that I'm describing, you're like, oh, that's what express preemption looks like. Okay,
So do you expect to see industry-focused wage regulations spreading to other jurisdictions as well? Or is that something you think is going to be unique to California?
I don't think it's unique to California, because I think the thread that between the fast food minimum wage and the healthcare minimum wage is labor organizations, I would say one very specific labor organization that has a major presence in California politically, and has a lot of members in California. And that is definitely, if we're looking at this as don't underestimate organized labor, and that's how I look at it, then absolutely, I would say Washington or another Western state could absolutely be next, because this is the long game. I talk to people a lot about how we got here and the kind of legislative compromises that occurred. In both instances, there were very nasty ballot propositions that were insanely expensive that had to go forward and then be pulled for these laws to go into place. And we're talking about a lot of money and a lot of power if a certain result is wanted on either side, on the industry side or on the union side, right? And so where there's that sort of circumstances to allow that, I think it's entirely possible.
Very unique aspect of California politics with the legislature and the ballot propositions sometimes acting in concert with one another, and one providing leverage for certain stakeholders with respect to the other.
It was a wild session in California.
It's fascinating. I just had popcorn, just shoveling popcorn. What is going to happen?
Well, I think, Nisha, you need to find some things more enjoyable to watch while you eat your popcorn. But so what common thread in all of these as we head into 2024, what are you seeing that employers need to focus on, and what's the major takeaway?
Your employees. I mean, I don't know how so long we've been concerned with the bottom line, and I get it. You're a business. You have to operate and turn a profit. But if you have unhappy employees, they're going to cost you, whether it be in litigation and, by just leaving. Turnover count for a lot of people, that turnover is brutal. So I would really focus on ensuring you have a culture of inclusivity and just trust, that they have some sort of trust in the company they work for.
And I would just acknowledge it's hard, right? I agree. Completely
So
agree. Hard. We were just talking about how important it is for an employer to put themselves in the perspective of the workforce and try and create a culture of inclusivity and make sure people are heard. It does feel sometimes like post-COVID, post-staffing shortages, post-social unrest, employers are coming from behind and they're on their heels a little bit in addressing these things. At the same time, we have a workforce out there, we have labor organizations, and we have plaintiffs' lawyers that many are evolving toward a message of tear it all down. And so what I told a client yesterday was, you've got, maybe a small business owner on their heels already. And at that same time, some members of their workforce, some members of the plaintiffs' bar, and some labor organizations have essentially been building up an arsenal. And so employers really need to manage through their expectations when it comes to a lot of the things we were talking about.
Well, and it's hard because so much of it is counterintuitive. So much of it is your gut says, I don't want people using marijuana. I don't like it. Or I don't want people fighting about politics in the break room. So it's so hard for employers. I mean, people ask me how to avoid wage and employment lawsuits in California. And I say, don't have employees in California. I mean, it's, there's a great profit aspect here, but it's really hard.
Well, an excellent discussion on all of these issues. Let's take a few moments at the end. We're now at our segment where we call the deeper dive. I'd like to hear a little bit about what life is like for you or has been outside of work and outside of your labor and employment expertise and pursuits. So here's the question. What book have you read or movie have you watched, say in the last 10 years, that has had a significant impact on you as a person, not necessarily your profession, but just as a person?
So I am going to ruin it by bringing it a little bit back to my profession, but I guess that's a trend, right? But anyone that knows me knows I'm obsessed with documentaries regarding, or sometimes fictionalized, regarding organizations that start out to do the right thing and then plainly do the wrong thing. And there's a lot of really smart people in the room, including lawyers, and they let it happen.
And you wonder, what were you doing?
And I am in a situation where so an example is Theranos. I think I've watched and listened to everything about Theranos. Example is the WeWork, even the fictional, right? And then most recently on Netflix, there was this series called Bad Surgeon, which wasn't really about that, but it was ultimately, there was an aspect of a hospital in Stockholm that knew their doctor was doing something horrendous, and they were at a place where they felt they needed to cover it up, which didn't work. And it seems to never work. But what I am always trying to figure out is, for the lawyer in the room, at what moment could they have spoken up and changed it? If I'm ever in a room like that, where I know from a groupthink perspective, this is all going south, how do I change the psychology of the room? And so I don't have it figured out yet, but that's what I like to focus on.
Well, so many times the people in the room are focused on what's the expedient thing to do, what's the minimalist thing to do. And there needs to be someone that raises their hand and say, wait a second, what's the right thing to do?
Exactly.
Because many times there's moral clarity. The temptation is overwhelming, though, to not follow that person.
And what I'm interested in is all of the instances that I mentioned, all of the people in the room truly believe that whatever decision they were going to make, they were making for some greater cause. Like, I mean, you fill in the blank, right?
Watergate.
What do you, how do you rein that in, right? I think that's what I enjoy about those documentaries.
So not quite as heavy, perhaps, maybe from you, Heather?
Legally Blonde.
We'll go the opposite end of the spectrum.
Absolutely joking. But I don't watch heavy stuff at night. I am wiped, and I'm usually reading some sort of fiction book. Right now I'm reading a book about dragons that's completely out of my normal coho, which are these like very soft, nice female stories with a strong female character in them. But I actually, every January, I do read a self-help book, if you will. And I read Atomic Habits last year, and I did really like it. I'm the mom of 2 young kids. My husband's an attorney. I'm an attorney. And I felt like everything was just out of my control. And I did really like a lot of the messages in Atomic Habits. And that's been one I've recommended to others.
Well, very good. I enjoy travel with my wife. My wife and I are empty nesters now. And so my reading habits usually correspond to whatever part of the country or world we're going to be visiting. So we visited France recently, and I did a deep dive into all things French, including everything from the French Revolution to D-Day. And I kind of rediscovered Ernest Hemingway and his Movable Feast, which I listened to on audio, was just fantastic. I really enjoyed hearing his amazing writing ability and talking about it was written at the end of his life, a couple of years before he died, but it's a retrospective back to very early in his life, I think in the late 1920s, about life in Paris back in that era. So it's a very sentimental retrospective when he was, just really at the end of his life, reflecting on all of these things. I found it very, very interesting and sort of pre-gaming the trip.
That's awesome. When you said France, I thought you were going to go cheese. No, it's the revolution.
I can eat cheese while I eat the feast. I can eat the cheese while I listen to the Movable Feast. So, well, thanks again for being here. I'm appreciative of all your thoughts and your insights. I want to also thank our listeners for tuning in. I'm indebted to the extraordinary team at Dorsey for making this podcast and episode possible. For more resources on this and other litigation risks, go to litigationrisk.com, where more information can be found, including a book on managing litigation risks written by yours truly. Until next time, my friends, this is yet a reminder that there are a lot of sharks swimming out there in the murky waters, so swim safely.
This podcast is not legal advice and does not establish an attorney-client relationship or create any duty of Dorsey & Whitney, LLP, or those appearing in this podcast to anyone. Although we try to assure that the content of this podcast is accurate, comprehensive, and reflects current legal developments, we do not warrant or guarantee those things. The opinions expressed in this podcast are the opinions of those appearing in the podcast only, and not those of Dorsey & Whitney. This podcast is considered attorney advertising under the applicable rules of certain states.